Hi guys, it's Kathy. I hope you're doing well. Time for OJ. We are we are not at video 200 yet, but we are close. Not my videos, their videos. So if we keep going, we could get to 200 pretty quickly. 250-ish is when we're halfway. So we're almost up to halfway, but remember, it's going to go a little faster now than it was before, which is amazing. Just amazing. Let's go.
Items, I will remove the gloves so as not to contaminate myself or other items of evidence.
Okay.
There we go.
Now, when you left Rockingham that morning, did you have any information to the effect that you were going to return?
Yes.
Can you just give us in general terms what you were told?
I was told that a search warrant was being obtained and I may be required to come back to do the inside of the residence.
Okay. So you did not go inside the residence on June the 13th in the morning?
Not in the morning.
Okay. Where did you go after you left Rockingham that morning?
After Rockingham, I proceeded on to 875 South Bundy.
Now, when you went to 875 South Bundy, where were the items of evidence that you had collected, item number 1 through 10 from Rockingham that morning?
Items 1 through 10 were in bags locked in the back of the crime scene truck.
Okay. Now, before you leave and actually lock those bags away into the crime scene truck, do you do any inventory? Did you do any inventory to see what you had prior to locking them away?
Yes.
What did you do?
Each item that we had written in our notes was accounted for.
So what do you mean by that?
We identified each number individually, item number 1, item number 2, item number 3. We made sure that there weren't 2 number 3s or missing numbers either.
Okay, so you made.
Overruled.
Did you do this alone or did you do it with someone?
I did it with Miss Mazzola.
Okay, and when you say that you're going through, make sure you don't have 2 item number 1s or 2 2s or whatever, does that mean that you're making sure that you have 1 coin envelope that has number 1 on it, 1 coin envelope that has number 2, etc.?
Yes.
Okay, and that you have a total of, at that time, 10 items?
Yes.
Now, you testified earlier that in the 80 some odd pages of reports that you generated in this case and notes that there were some clerical errors.
Yes.
Is it reasonably possible to make a clerical error of writing down the wrong number on a coin envelope using the procedures that you use?
Sustained. Phrase question.
Okay. Could you make a mistake on the coin envelope by writing the wrong number on it?
Sustained. Phrase question.
Could you make a mistake on the coin envelope by writing the wrong number without having caught it during this inventory procedure?
Sustained.
I didn't hear the grounds.
It's leading.
What?
It's leading.
Okay, sir, how careful is this procedure of writing the numbers on the coin envelopes and then inventorying them to make sure that you have the right numbers?
We are very careful when we collect evidence. We collect evidence one at a time, making sure that the envelope that we put the evidence in is the same number as the one next to the card.
Overruled. Thank you. And how careful are you when you do this inventory at the end prior to leaving the scene?
It's vague. How careful?
Okay, I mean,
I just haven't described the procedure. Describe the procedure.
okay, why don't you tell us in detail the procedure?
What
do you,
safeguards are there?
let me start with this, Mr. Fung. With respect to the items of evidence in their packaging, where are those when you're doing this inventory?
The items are in the back of the truck together.
Okay. Do you put the items in numerical order or are they in random order when you do this inventory?
Overruled. Rephrase the question though.
Okay. What order are the items in when you do this inventory?
The items are in numerical order.
Okay. And then how do you go through them?
I go through them sequentially.
from 1 to 10?
Yes.
Approximately what time did you arrive at the Bundy location?
I arrived at the Bundy location at 10:15 in the morning.
Okay. And what was going on there at the time that you arrived, 10:15 that morning or so?
The area had quite a bit of news media around, and detectives and coroner personnel were present.
Did you see the coroner personnel doing anything at the scene as you arrived?
Yes.
What did they appear to be doing?
They appeared to be processing the body of Miss Simpson.
And when you say processing, where was that taking place?
That was taking place at the east of the front gate.
Do you know whether you saw her in her original condition, or do you know whether she'd already been moved by the time you arrived?
Sustained, calls for speculation.
Do you know whether, did you see whether the coroner's investigators, did you see whether when the coroner's investigators first got there and started touching the body, or were they already doing it when you arrived?
They were
Or will
they were already doing something when I arrived.
Okay. What were you doing while that was occurring?
I was waiting for a briefing from Detective Lang.
And at some point, did you also see something occurring with the body of Ron Goldman?
Yes.
What did you see in that regard?
I saw at one point, the body of Ron Goldman being processed also. I didn't stick around for the whole thing. Then I was back and forth at the truck.
Okay. And at some later point, did you get a walkthrough of the location from Detective Lang?
Yes.
What happened during the walkthrough?
Detective Lang told me of different items of evidence he wanted me to collect. He showed me some clothing in the cage area. He showed me a trail of what appeared to be bloody footprints and a trail of blood leading towards the west end of the location.
Now, when you looked at these items of blood drops that you described as being the trail, what condition did they appear to be in?
They appeared to be fresh blood stains.
Did they appear stepped in?
No.
Now, did you begin to process the crime scene for collecting the evidence that morning?
Yes.
And did you do that alone, or did you also do that with Andrea Mazzola?
I did that with Miss Mazzola, yes.
In terms of collecting the blood stains, did you do that as a team, as you described at the Rockingham location?
Yes.
Sustained.
How did you do it?
Assumes facts not in evidence. Assume facts not in evidence.
How did you do it? How were the items, the blood items collected?
So Carla, I don't know. Unfortunately for you, we have the B team lawyers today and for the next at least month. The B team lawyers. So no Marsha, no Dearden, no Cochran. They're going into all sciencey stuff. So like a couple months ago, I was screaming and swearing at the screen because the lawyers were just ticking me off so bad. These lawyers are just talking about science, and that's what we're going to be for the next month. But that's part of the trial.
The blood items were collected in the same manner that was described earlier on the board.
Okay, using the same procedure.
Yes.
And when you were actually doing the evidence collection, I mean, you and Miss Mazzola, were you wearing anything on your feet?
Yes.
What were you wearing on your feet?
We were wearing protective booties.
Your Honor, at this time, I'd like to show the witness an item of evidence that's been marked as People's 163B for identification.
All right, 163B.
There are actually two, what appear to be two paper-like objects. Sir, showing you those items. What are they?
These are the type of booties that we were wearing that day.
How are they worn?
They are placed over our shoes.
Can you just hold one of them up so that jurors can see it all? What is the purpose of wearing those booties?
I wear them to protect my shoes from biological evidence.
So the booties are to protect the wearer?
That's the main use for them, yes.
Okay. And do the booties serve any function in terms of protecting the crime scene? I'll withdraw the question and ask another question, Your Honor, if I might. Sir, if you were to step in some blood and with the booties on and then step in some evidence, do the booties have some sort of property that would prevent cross-contamination from occurring?
No.
Okay. Are there any disadvantages to wearing booties at a crime scene?
Yes. Booties are somewhat cumbersome in that they're much larger than your regular shoe, and they could track. There's more chance for tracking or stepping in something that you don't want to step in. Also, they're quite slippery and could injure yourself if you're not careful.
So given those disadvantages, why were they worn at the Bundy location?
I wore them because I felt there was quite a bit of blood out at the scene, and I just didn't want to get the blood on my shoes.
Okay. Now, when you were at the location, were you or Ms. Mazzola wearing any lab coats?
No.
Were the fingerprint people wearing lab coats?
Yes, they were.
And you testified that at crime scenes, you would be in charge of the fingerprint people?
In some crime scenes, yes.
Okay. Do you know why the fingerprint people wear lab coats at a crime scene?
The fingerprint people wear lab coats because they deal with fingerprint dust, which gets all over the place, and the dust can ruin your regular clothes. So they'll wear the lab coat to protect their clothing.
Okay. Now, did you use the procedure that you previously described when you were talking about how a stain is collected, of laying out the numbers and doing the measuring?
Yes.
Thank you. And since you knew that you were going to go back to Rockingham later, what number did you start with at the Bundy location?
I started with photo ID number 100.
Why was that?
Well, as stated before, I knew I would have to return to Rockingham, and I wanted to keep the numbers there in sequential order.
Okay, does that mean that when you went back to Rockingham, you wanted to item number 11 to be your first item of evidence?
Upon return, yes.
Okay. So why did you choose starting with 100 instead of 50?
This is
or
fun,
70?
all right. Yes, it is.
I felt that that was a safe number to use because I didn't believe I would have another 90 items of evidence to go through at the Rockingham location that day.
Okay. So the number cards that you laid out started with 100. What was the last one?
The last
At the
Sort of a big deal what he just said about the booties and the lab coats, because the defense team was making a huge deal out of no booties on these shoes, thinking that the no booties was them dragging, the booties were there to stop them from dragging contaminants into the crime scene. Fung is saying no, it's to protect our shoes so they don't get blood on them. It has nothing to do with them dragging contaminants into the crime scene, which I wonder now if it's changed. Probably has.
Bundy location.
the last photo ID card we used was 119.
And those are photo IDs,
Yes.
is what you're saying. Okay. Now, at some later point, did you assign property item numbers to replace those photo ID numbers, or in addition to the photo ID numbers?
Yes,
When did that take place?
that occurred back at the laboratory.
Did you enter the property identification numbers that you eventually placed on items uh, on the crime scene identification checklist?
Yes,
Okay. So does that list then correlate the property numbers with the photo numbers?
yes,
Now, in order to give us specific testimony as to the item numbers, in other words, property numbers of various pieces of evidence that you collected at the location at Bundy, would you have to refer to your crime scene identification checklist?
yes,
Okay. With respect to the caged off area that you referred to, did you what did you collect an item number 36 from that 35 from that location?
yes, I did.
And what was that?
That was a set of keys.
Did you collect an item number 36, or was one collected in your presence?
Sustain, rephrase the question.
Did you see an item number 36 being collected?
Yes,
What was that?
that was a pager.
I'm not disagreeing with you, but also the whole prosecution, because we've been at this. This is the 70th day of the trial, I think. We're going to hit 71 today. And I heard elsewhere, because this trial is old. So I heard elsewhere that her blood was found inside the Bronco. Her blood was found on his socks, OJ's socks. In the beanie was some of Ron's DNA or whatever. And we haven't heard any of that in trial. Maybe a tiny little piece here and there. But we've heard a lot about there was 11 cents on the parking lot and the dog was barking. I mean, we spent weeks and weeks and weeks on dogs barking and weeks on the amount of change that they found in the driveway. Nothing about the murders. Like we have not heard anything about the murders. So I mean, it was all the testimony so far has been a bunch of bull. It's just been a bunch of bull that had nothing to do with the murders so far. It's just been blah that frustrates you.
And what about item number 37? What was that?
37 was a glove.
Do you remember who specifically collected that item?
Criminal Mazzola collected that.
Did you see an item number 38 collected?
Yes,
What was that?
that was a blue knit hat.
And an item number 39?
Yes.
What was that?
Item number 39 was an envelope containing a pair of glasses.
And what about 40?
40 was a ring.
Now, with respect to these items, how did you package those? Were those in coin envelopes or some other type of package?
The keys and the pager were placed in coin envelopes. The glove, the hat, and the envelope with the glasses were placed in paper bags, and the ring was placed in a coin envelope.
And eventually, were those then assigned the DR number in our case that you previously read out?
Yes.
Your Honor, at this time, I'd like to mark as people's next in order. It's 165, a map of the Bundy location.
All right, 165. Have you shown that to counsel?
Yes.
This is a chart, Mr. Goldberg?
Yes, Your Honor.
All right. All right, Mr. Tretlow, why don't you keep that closed for just a second? Why don't you close that up for just a second? All right, ladies and gentlemen, I'm going to take a 10-minute recess at this time to change court reporters. Please remember my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations, and do not allow anybody to communicate with you. If you'll just step back into the jury room, and we'll resume in 10 minutes after we change court reporters. Mr. Fung, you can step down. 10 minutes.
And it's not Judge Ito's fault, although some
Right.
of it is.
All right, back on the record.
Because he can't tell them what to present. He can't tell them how to present their case. And he said a couple times, I've already seen this 5 times, I've already seen this 10 times. So, he can do that. But what I don't understand is, like, this is televised. This was televised. How can there not be scores and scores and scores of lawyers talking about how stupid the prosecution case is, and how can the prosecutors not see that? And you know what I mean? I don't know. Okay, I hear that. I hear everybody saying that, but I haven't. We had Mark Furman on the stand, and there was a little bit of that, just a tiny bit of that, but there wasn't a lot. It was just really actually one day that they dropped the N-word quite a few times, and I got demonetized. But I hear he's coming back, and then we're gonna hear it. But we have not heard. Okay, 'cause we haven't heard anything terrible like everybody is saying yet.
In the Simpson matter, all parties are again present. Deputy Mayor, let's have the jurors, please. All right, the record should reflect we've been rejoined by all the members of our jury panel. Mr. Dennis Fung is still on the witness stand, undergoing direct examination by Mr. Goldberg. Good afternoon again, Mr. Fung.
Good afternoon.
You're reminded you were still under oath, sir. And Mr. Goldberg, you may continue with your direct examination.
Thank you. Sir, directing your attention to the diagram that's been marked as Peoples 165 for identification. Do you recognize that?
Yes, I do.
What does that depict?
This depicts the different areas from which I had collected various items of evidence, biological evidence.
Have you had the opportunity to take a look at this diagram prior to today to make sure that it was correct?
Yes.
When this diagram was being made, did you have the opportunity to look at versions of it in order to make sure that they were correct in terms of the measurements and the locations that items were found?
Yes.
Okay. Now, starting with item number 41 on this chart, can you tell us where that is? Oh, I'm sorry. What was the first item, sir, that you collected, the first stain that was collected at Bundy?
That would be item 41, which
Okay.
is
It's not on. It doesn't appear to be on here.
No.
Where was item 41 collected from?
that was collected from a stump in this area here.
For the record, he's referring to the area that has been described as the fenced-off area that's on the north side of the walkway.
Yes.
And for what purpose was item 41 collected?
Item 41 was collected as a reference for the male victim.
Well, when you say now, when you say that it was collected as a reference for the victim, what do you mean by that?
That was where the male victim had been, and that was where he had bled.
Okay. Now, with respect to item number 42, is that depicted on this chart?
Yes, item 42 is depicted here.
Now, that has a little photo card. Maybe we can have that one up there. Item 42. Sir, that has a card in it.
Hold on. Small monitor down below. Juror number 1, can you see that? All right, thank you.
That has a card in it that says 107.
Yes.
Is that correct? Now, what does that 107 represent?
107 is a photo ID card representing the stain at the base of the step right here.
And that was eventually,
The more I think about this, guys, if Furman is as bad as I hear he is, on cross-examination, then I might just provide the links to that a specific episode, and you guys might have to watch it on there, because I don't want YouTube to, delete my account. I just don't. I'm not gonna let my account be deleted over OJ when I'm only getting like 80 people watching it. You know what I mean? That would suck. So we'll see. I'm gonna watch it ahead of time. And if Furman is bad, I have two options. I can either go through and beep out all of the bad, which would take me forever, maybe. I don't know. I have to see. Or I'm just going to give you the link, and you guys are going to have to spend a day and watch it, because you can easily watch it on that channel. So, I mean, it's better than me losing my entire channel over Mark Furman. I mean, that would just be horrible. I know it was televised, but hate speech wasn't as bad back then as it is now. Like, it wasn't as, people didn't care back then for how bad hate speech was as they do now. So we'll see. I'll watch it ahead of time and see what I'm gonna do.
signed item number 42.
Yes.
Now, where specifically was that stain taken from?
Just want to show you on the notes, or I mean on the photograph, or
Maybe you can show us on the diagram.
on the diagram. It was collected from right where this dot here is.
Where the call out line is that leads to 42.
Yes.
Well, how close to the riser of the first step was that stain collected?
Within inches, 1 to 2 inches.
And for what purpose was this stain collected?
That was collected as a reference for the female victim.
So when you say reference for the female victim, is that again something that you believe to represent the female victim's blood?
Yes.
Now, sir, direct your attention to item 44 for identification. Perhaps we can have that photo. Where was that collected from?
That was collected from the north gate, or the north fence area right here,
Okay. And that was originally assigned photo ID number
109.
Does the call out line accurately portray where that was taken from? The
Yes.
fence where that was taken from. Okay. Next, directing your attention to item number 47. If we could have that picture.
47 was collected along the north walkway, and it was collected right here,
Okay, so again, the call out line shows where that was collected.
pretty close, on this diagram within 6 inches.
And what about the photo ID number? Was that number 112 as shown in the photograph?
Yes.
And directing your attention now to 48, item 48.
Item 48 was collected here.
In the area where the call out line suggests.
Yes.
And by the way, what is the margin of error? What do you say on the call out lines on this diagram?
They're within inches, maybe a foot at the most of difference.
Okay, so we're talking about fairly general, well, not general locations, but there is some margin of error on this chart.
Yes.
Right. And with respect to item 49 for identification, does this chart depict where that was located?
Yes, it does. 49 was collected from the steps, and that is right here.
Okay. And now directing your attention to item 52 for identification. Excuse me, let's do 50 first for identification. Item number 50. Does this chart show where that was located?
Yes, it does.
Was that located on, where in reference to the back gate is that?
That is east of that gate.
Okay. And now item number 52 on this chart. Where was,
Item 52 was recovered from the driveway. That's depicted here.
and again, as with the rest of the items that I've asked about, the photo ID number is represented in the photo itself.
Yes.
And now with respect to item number 54 for identification, where was that collected from?
Item 54 was collected from the corner of the front gate.
And now there are two photographs on the diagram that's been marked 160.
Carla, thanks for watching with me. This is so cool. This is so nostalgic. I mean, it tugs your nostalgia from day one. I can't wait till the defense comes on and we can watch it. I think, yeah, like once the defense comes on, this becomes a whole new trial, and I can't wait to see it with you guys. Thank you.
65 that appear to have a card in them with 119. Do both of those depict what was eventually assigned item number 54?
Yes.
One is a close-up of the other.
Yes.
And 51, where was that collected from?
51 was collected from this south fence right here.
Okay, now which side, if you can look at the photograph that has the 116 card, is that 116 card on the north side of the fence or on the south side of the fence?
That's on the north side of the fence.
The side closest to where Nicole Brown's body would have been.
Yes.
All right. Now, there's also an item that we don't have a photograph for, item number 57. It says label in the right-hand corner of the chart, just above where it says item number 54.
Yes. There was some type of label collected from the walkway, and that was located right here.
So the call-out line again indicates the general location that was found.
Yes.
What was the purpose again of, why was this label collected?
That label was collected at the request of Detective Blank.
And what did the label say on it?
According to my notes. The label said Bonita, Ecuador.
Now, we also have two photographs up here that appear to depict shoe prints. Is that correct?
Yes.
Looking first at item number 55. Maybe we can have 55. Does the call out indicate on the chart, People's 165, the location that this stain was collected from?
It's fairly close. It was a little more east.
Okay. And now directing your attention to item number 56.
56 was also just a little bit more east.
Okay. East of where the call out line says it was.
Yes.
So in reviewing these photographs, all the photographs on this Bundy Drive Biological Evidence Board, People's 165, did you compare them against your notes to make sure that the photo ID numbers and the item numbers corresponded?
Yes.
And that the general locations that the call out lines had them were depicted the general location where it was found?
Yes.
He's doing it to make sure that each thing he talks about is the exact same number, and we can all see. I mean, he'll be able to see.
Now, at some later point on July the 3rd of 1994, did you return to the Bundy location for the purposes of collecting some additional stains?
Yes.
And how was it that you got notified to return to the location?
I was requested to respond to 875 South Bundy by telephone. Detective Blank called me.
Approximately what time did you arrive at Bundy on the state?
I arrived there at 11:30.
What did you see
Oh,
when
I
you arrived?
can't wait to hear that.
I saw
That would be great.
brown colored stains on the rear gate.
on the rear gate, are you talking about what on this diagram, People's 165 has been labeled the back gate?
Yes, right here.
Approximately what time did you collect those stains?
I collected them at approximately 1:45 in the afternoon.
Okay. Now, directing your attention back to the diagram 165 for identification, item number 50 has a card in it, photo number 115. Is that correct?
Yes.
Okay. And item number 115 and 116 also contains a card with a number 115 in it. Is that correct?
Yes.
Okay, so there are two 115s.
Yes.
One 115 is from the 13th and the other from July the 3rd.
Yes.
Now, did you have occasion, Mr. Fung, to take a look at some photographs that were shot on June the 13th prior to testifying here today?
Yes.
Your Honor, at this time, I'd like to mark as People's 166 for identification
All right, 166.
what appears to be a photograph of the rear gate, and I'll place a 166 on the reverse side of that.
All right.
Perhaps we could have, it's,
Okay, so I have it sped up at 1.25. All right. What's happening is every time Judge Ito speaks, he speaks a little faster than everybody else. But you know when you're like not paying attention and then somebody asks you a question? Maybe back when you were in school or, just in your life, when someone asks you a question, when you just aren't paying attention and you like wake yourself up and then you speak kind of fast to let them know, oh yeah, I know what's going on. Every time Judge Ito speaks now, he's a little faster than he used to be. So it makes it sound like he just like snapped to attention and is like, oh, well, da, 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 da. And it's hilarious. Pay attention, Judge. Pay attention.
yeah.
Don't you let them push you around. Don't you let them. Don't you let them. You stand your ground. Yeah, that's right. Get him, Marcia. Get him. Now, while you're there, just punch him right in the throat. One little throat punch would be awesome right now. Yell at him. Yell at him.
Counsel
Body
wants to
slam him.
approach, Your Honor.
All right. Well, of course,
Push him.
fine, like
Yeah. You saw that? She pushed him. She didn't really push him.
All right, Mr. Goldberg, you may continue. People's 166.
Guess what I'm about to look up? Of course not. Of course not. Of course not. Guess what I'm about to look up? I don't remember when they stopped Celebrity Deathmatch, but I'm going to look it up and I'm going to see if they have Marcia in there anywhere. I'm going to look it up right now while we're listening to Fung.
Sir, showing you People's 166 for identification.
One piece. Court counsel. Name on.
Did you have the opportunity to take a look at this photograph prior to your testimony here?
Yes.
Did you look at it with a magnifying glass?
Yes, I did.
And is this a photograph that was taken on the 16th of June? I mean, the 13th of June, sorry.
13th of June, yes.
Did you have the opportunity to compare that photograph to the photographs which were taken on July the 3rd at the time that you collected 15, 16, and 7, 115, 116, and 117?
Yes.
Does that appear to be in the same location and the same configuration as the stain that was collected on the 13th?
Yes.
Right.
That's what I heard.
I mean, does the stain in the 13th photograph appear to be in the same configuration, the same location as the stain that was collected on July the 3rd?
Yes.
All right. Now, do you specifically recall having seen that stain when you were at the location on the 13th?
No, I do not.
Okay. Do you know whether do you have a specific recall of whether it was pointed out to you?
No, I do not.
You don't recall one way or the other?
No, I do. No.
Had you known of that, had you seen it yourself, would you have collected that?
Yes.
Now, you said that it was your practice to collect representative samples. Why would you have collected this stain?
This stain was on a different medium than the ground, and it was a location that was relevant to the crime.
Okay. So if you had the opportunity to go back and reprocess the crime scene at Bundy, if you could do the 13th all over again, would have you liked to have collected the stain?
Absolutely.
Now, getting back to the photographs that were taken on July the 3rd, showing 115.
I have to go now. Take my daughter to work. I'll be right back. I'm going to let this play. Feel free to chat. I'll be back in just a few minutes.
Can you explain to us why there's
30
a
ish.
photograph number 115 taken on the 13th and a number 115 in the photographs on July the 3rd?
The photo ID 115, which corresponds to item 50, was done on June 13th, before item numbers could be assigned.
And that was when you were assigning photo numbers 100 through, I think you said 119. Is that correct?
Yes.
Okay. Can you continue your explanation as to why the two 115s?
By July the 3rd, 114 items of evidence had been booked into property division. And that was the next item number that was going to be used. And it is preferable to have the item numbers and the photo ID numbers coincide. So when we get to the trial phase, the jury isn't confused.
And the attorneys too.
Yes.
Okay. Your Honor, perhaps I could make a People's 166A of the item that was shown on the court screen of 166.
Part 166A, hard copy.
Now, with respect to the three stains that were collected on July the 3rd, did you use the same technique in terms of what happened to the stains to dry and package them that you did with the stains that were collected on the 13th?
Yes.
All right. All right, now getting back to June the 13th and the location of 875 South Bundy. Did any of the blood drops at that location appear to be stepped in?
Along the trail, no.
Okay, and along the trail, you mean which item numbers through which item numbers?
I am referring to item numbers 112, or excuse me, those are photo ID numbers. Item numbers 47, 48, 49, 50, and 52.
When you were out at the scene and looking at these various blood dots as well as the shoe prints, did Detective Lang ask you to do anything in particular in terms of documenting or analyzing those shoe prints and the blood dots?
Yes, he did.
What did he ask you to do?
He asked me to measure and document the different shoe prints.
And how did you measure the shoe prints?
I placed a tape measure down and measured them with reference to items that are immovable within the residence.
Okay, so you documented the measurements of the various footprints.
Yes.
Did you also document the measurements of the various blood dots on what you've described as the trail?
Yes.
Okay. And for what purpose did Detective Lang say he wanted you to look at it to determine what?
Sustain.
Well, I asked him what he said.
But why don't you rephrase it?
Okay. When Detective Lang said something to you, said he wanted you to look at these, what did he say he wanted you to look at them for?
He wanted me to do it. I think his term is. The word he uses escapes me right now. I'm sorry.
Did he use a term that wasn't typically used any longer in the that you do not use as a criminalist?
Yes.
Okay. Did it have to do with the strides?
Stride analysis. Yes.
And what, if anything, were you trying to determine by measuring the footprints and the blood dots?
I was asked to determine whether the person was running or walking.
Okay. And what kinds of factors did you look at in order to make that determination?
I looked at the distance between the shoe prints. I looked at the shoe prints themselves to see if there was any splashing effect. And I looked at the bloodstains to the left of the shoe prints to determine if there was any trailing or not.
Okay, well, let's break that down for a second. First of all, did you make any preliminary determination as to the shoe size?
Yes.
What was your preliminary determination?
The preliminary determination was that it was a large shoe size consistent with being worn by an adult.
Okay. And you said that one of the things that you looked at was whether or not there were splatters off of shoe prints.
Yes.
Why were you looking at that?
When a person runs, they will have much more force when they hit the ground with their foot, and there will be somewhat of a splashing effect on the surface.
Did you see that kind of splashing effect?
No.
Right. And another thing you said you were looking at was the distance between shoe prints.
Yes.
For what purpose were you looking at that?
When a person runs, they will have a longer distance between each shoe print than when they walk.
And was the distance here for an adult relatively long, consistent with running, or shorter?
It was relatively shorter.
Okay. And finally, you said that you looked at the trailing or tailing on
Yes.
the blood dots. What did you mean by that?
When a drop of blood hits an object, when it has some type of velocity besides going down, it will typically have a splashing effect in the direction that it is traveling. And you can determine direction by analyzing that.
Did you see any evidence of significant tailing on these blood dots?
There was no significant trailing, no, or tailing, no.
And would that be more consistent with someone who was running or moving more slowly?
There would be more tailing with someone who was running.
Okay. Now, respecting the shoe prints and the blood dots, did you notice where in relationship to the shoe prints, the blood dots were?
Generally speaking, the drops were to the south of the shoe prints or to the left if the person was walking in the west direction.
Okay, so if a person were walking towards the west direction, the back gate, the dots were generally to the left.
Yes.
Respecting the board that we've marked as People's 165 for identification, item number 48, perhaps you need to take a step off the witness stand. Can we see this again? Is one of the shoe prints that you observed at the scene on the 13th located in this photograph?
Yes.
Can you tell us where it is by pointing on the diagram? I think you're gonna have to point over here.
It is right here.
Okay, but can you tell us where in the photograph the shoe print is?
Right upper right-hand corner.
Can you describe it a little bit for us so we can see what we're looking at? Is it a whole shoe print or part of a shoe print?
It appears to be a partial shoe print. Right here, and this is the outline of it.
And the blood dot is also located in this photograph next to the card 113.
Yes.
Now, can you tell us how on the diagram this item would be oriented? In other words, which way is west on the photograph?
On the photograph, going up is west. So to orient this properly, you would have to turn it on its side.
So when you're at the scene and you're looking at this partial shoe print, if the person were headed in a westerly direction towards the back gate, the blood dot is to the left.
Yes.
Now, regarding item number 47, we don't need to take a look at that, but just referring to the diagram, People's 165, was there also a shoe print in the vicinity of that blood dot?
Yes.
And where was that using the diagram?
There was a shoe print up in this area here.
On the diagram, he's pointing to one tile to the north of where the blood dot is, Your Honor, and it's adjacent to the blood dot itself.
Yes.
Well, he's pointing to a row of tiles, again, for the record, that's the row above the blood dot to the north on this diagram. Mr. Fung, why don't you point to it again?
Maybe we can count the number of tiles starting from there. Yeah. Count the number of tiles starting from the beginning.
Appears to be indicating a location that's approximately 1 foot on the diagram, slightly above and slightly to the left. He agrees. Pretty good for not being able to see it, isn't it? I can see right through it.
Okay. It's what the judge just said, correct?
Absolutely. Of course.
Okay. Now, when you package the various items that you collected that are represented on this board 165 into the coin envelopes, were the coin envelopes given the, and I'm talking about the ones on the 13th, were they given the photo ID number or the item number?
It's the same. What's your rephrase?
Well, with respect to every item that you collected on the 13th, was it given the photo numbers or the item numbers?
With respect to the items that I collect on June 13th at Bundy, the evidence was marked first with photo ID numbers.
Okay, and then later on, you assigned the item numbers.
Yes.
Where was that? Was that at Bundy or back at the lab?
That was done at the laboratory.
And then were those coin envelopes given the DR number that you read off in this case?
Yes.
Prior to leaving the Bundy location, did you do anything to recheck the items that you had collected?
Prior to leaving Bundy, I conducted an evidence inventory for the items of evidence we collected at Bundy.
And was that the same procedure that you described earlier when you were talking about doing the inventory at Rockingham?
Yes.
Right. Yeah. Where did you put the items of evidence that you had collected from the Bundy location?
The items of evidence were placed in bags.
No, I mean, but were they taken and put in the crime scene truck?
Yes.
Was the crime scene truck locked?
Yes.
And when you were processing the Bundy location, where was the Rockingham evidence from the morning?
The Rockingham evidence was also locked in the back of the crime scene truck.
Approximately what time did you leave the Bundy location on the 13th?
I left the Bundy location at approximately 3 o'clock, 3:15.
Where did you go after you left?
I returned to the Rockingham address.
What time did you arrive back at Rockingham?
I arrived back at the Rockingham address at approximately 3:30.
So when you left Rockingham in the morning, your last photo number and item number was 10, is that correct?
Yes.
So would the next item that you collected have been 11?
Yes.
Was 11?
Yes.
Who collected number 11 physically? Was it you or was it Ms. Mazzola?
That was physically collected by Miss Mazzola.
Do you recall who spotted it first?
No, I don't.
Did you see it?
Yes.
Where was it?
That was located on a wire that was hanging down along the south walkway at the Rockingham address.
That was the same side that the glove was collected from?
Yes.
All right, Mr. Goldberg, do you need People's 165 at this point since we're talking about Rockingham?
No, I don't, but I'm going to need to get to the Rockingham exhibit, and there's an issue that we'd like to discuss with that.
All right, let me ask the jurors then to step back into the jury room. There's something I need to determine with regards to the next exhibit. All right, Mr. Goldberg, the record should reflect that the jury has withdrawn from the courtroom. Do you want to show me this exhibit?
Yes, well, this is the exhibit that contains the two items that counsel objected to earlier, the sink, I believe, and the shower, where they were objecting on the grounds of showing the phenolphthalein test that was conducted. So that's the issue. We've now arrived at that point, Your Honor.
All right. All right, we discussed this matter briefly this morning, and Mr. Goldberg, you cited to the court the Coleman case. The court has had the opportunity to review the Coleman case, and I have reviewed each of the cases that Coleman cites. Do you wish to be heard?
I don't wish to be heard further, Your Honor. I'm going to respond to what counsel has to say. I mean, I think, as I understand the objections, I think we talked about that.
Your Honor, I did have a chance to look at Coleman over the recess. I think there are three significant differences which the court should bear in mind at this time, Your Honor. One is that, first of all, in the Coleman case, the evidence, it was determined that it was error to admit the evidence, although it was deemed harmless error, which had not been pointed out this morning during the discussion. But more importantly, Your Honor, the criminalist who tried to introduce the evidence in Coleman, like Mr. Fung in this case is not an expert in serology, was not an expert in serology, and that was a factor considered by the court as to why he was not the appropriate witness to introduce that type of evidence. We would submit to the court that, likewise, in the instant situation, Mr. Fung would not be the appropriate witness to introduce the evidence of any presumptive test done on these sinks or drains in the house. Secondly, Your Honor, in the Coleman case, one of the reasons they felt that it was not, that it was harmless error, excuse me, is that the actual items were brought in so the defense could do independent testing. In this instance, those two items were never preserved by law enforcement. And frankly, it's in that sense, there's a Griffin situation here as well, Your Honor, where we are basically precluded from having done any testing at all on those drains. As I pointed out this morning, Your Honor, the appropriate procedure would have been to simply collect some of the liquid in those drains, so any kind of confirmation testing could have been done back at the laboratory. That was not done here. All the other stains for which law enforcement received a positive presumptive test were actually collected. And there's no reason why these samples were treated differently. They certainly could have been brought back and a confirmation could have been done. But frankly, Your Honor, the third concern we have here is again under 352, which is that little pink Q-tip that you see there is not pink because it's showing blood. It's pink because that is the chemical reaction from the phenolphthalein followed by the hydrogen peroxide. That's the nature of the test. And there is this suggestion that he's reaching in with that Q-tip and pulling out blood, which he's not. As I pointed out this morning, Your Honor, there is a wealth of information in the scientific community that shows that this particular situation is fraught with the dangers of a false positive. One article that comes to mind is by Blake and Dillon entitled Microorganisms and the Presumptive Test for Blood. It's a 1973 publication and talks about this kind of situation where you do.
Blake?
What?
The same Blake?
It's the same Blake who's referred to in the Coleman case in a different context. But one of the things that Blake and Dillon point out in that research in the 1970s is that in damp, moist areas, such as a drain, where you have a lot of microorganisms growing and bacteria, you can easily get a false positive. Coupled with the fact that in pipes, if they're copper pipes, copper also gives a false positive for the pheno test. And I'm not talking about other kinds of vegetable matter, but if you look at the types of things that can give a false positive here, coupled with the fact that they didn't preserve that liquid, so it could have a confirmatory testing back at the laboratory, I think when you balance that, Your Honor, that the prejudicial impact does outweigh any reasonable probative value that it has, given that it's a presumptive test. Thank you.
Goldberg? Certainly.
Well, Your Honor, the only reason that this is at all difficult for the prosecution is because there's a tactical as well as a legal issue involved. Counsel, as I'm sure counsel is aware, the defense has also done some presumptive blood testing at the Rockingham location, and they're using the same class of test as we did in the phenolphthalein case with the phenolphthalein test. So if the court's ruling is that presumptive blood testing doesn't come in, period, regardless of who is offering it, maybe that's a decision that we can live with. But I just think maybe we should clarify whether that's counsel's position, because if it is, then perhaps we don't need to put in this evidence of the phenolphthalein test. What I would say, Your Honor, though, is that we do have some patches for this particular item that we could affix, and I would like the opportunity, if the court is going to rule, if indeed this is the defense position, to be able to fix the exhibit up. It shouldn't take that long. I believe Mr. Fairtlow can do that for us. And if that isn't the defense position, I'll respond to the legal arguments.
Counsel, let me suggest this. Let me suggest that Mr. Fairtlow apply his bandages at this point, allow you to consider the tactical matters over the evening hours. We do have an absolute stop time today at 4:30. I think, and then tomorrow, I have the feeling we're not going to get to that just yet anyway in the next 15 minutes, but we do need to quit at 4:30 today. Sure. And that'll give counsel from both sides the opportunity to discuss their chess match.
The problem with the patches, as I've just been advised, is that they are unadhesive once they're used, so they can't be removed once applied.
Well, I don't have enough Post-its to. The county only gives me these little ones anyway. Mr. Goldberg, do you have enough that you can just get through the next 15 minutes so we don't lose court time? Yeah.
I might just be able. I mean, I hate to take things out of order, but I suppose I could skip over the Rockingham evidence and move on to.
Well, you don't need this exhibit to do Rockingham just yet, do you? And you do have availability of the Laserdisc photos scrupulously, correct? Mr. Fairtlow indicates yes. I'm sure we could do the blood spots in the foyer and the sock collection in the master bedroom before we get to anything else. Let's do it that way. All right. Side of the jury. Let the record reflect we've been rejoined by all the members of our jury panel. Mr. Goldberg, you may continue.
Thank you. After the collection of item number 11, did you go inside the house?
Yes, I did.
And what was the first item of evidence that you saw inside the house?
The first item of evidence were a series of red stains in the foyer.
People's Exhibit number 121.
Sir, directing your attention to what's been marked as People's Exhibit 121 for identification. Do you recognize what's depicted there?
Yes, I do.
What is that?
That is the red stains that I previously was speaking about.
Now, when you collected these 3 stains, were they collected as a single item or as individual items?
Over.
They were collected as a single item.
And in this case, I take it that the number in the photograph also corresponds to the item number that it was eventually assigned. Is that correct?
Yes.
Approximately what time was item number 12 collected?
That was collected at approximately 4:30.
All right. Now, after collecting item number 12, did you go upstairs in the location?
Yes, I did.
Do you recall what was the next item of evidence that you collected?
The next item was a pair of socks in the master bedroom.
Apparently that has not yet been marked, Your Honor, so I'd like to mark as People's 167, a picture of the socks.
All right, People's 167.
Sir, directing your attention to what's been marked as People's 167 for identification. Do you recognize that photograph?
Yes, I do.
I can't see from here, but is there a tag in this photograph, an evidence tag?
Yes, there is.
What number is that?
That would be that would be number 13.
To your recollection, who physically picked these socks up, yourself or Andrea Mazzola?
That was me. I picked them up.
And you described 2 techniques that you used to collect this kind of evidence. Do you recall which one you used here?
No.
So it was either the scoop technique or the glove hand technique.
Yes.
What kind of packaging did you put these in?
Those were placed in a paper bag.
And that was assigned item number 13? The paper
Yes.
bag?
Yes.
And given the DR number in this case?
Yes.
And and did you then collect another stain from the upstairs area after collecting the socks?
Yes.
Where was that from?
That was collected on the floor in the master bathroom.
That's going to be People's 1.
All right, 168.
What does 168 portray?
168 portrays Criminalist Mazzola performing the phenolphthalein test on item number 14.
And can you tell us where in that photograph the stain is located?
The resolution on the monitor isn't that good, but the stain is close to where she is pointing with the applicator.
Did she physically collect that stain or did you?
She physically collected it.
Was that in your presence?
Yes.
And did she use the same procedure that you previously described in terms of collecting stains?
Yes.
And that was assigned item number 14?
Yes, it was.
And do you have an approximate time frame for when 14 would have been collected?
That was collected at approximately 4:40 in the afternoon.
Now, according to your crime scene identification checklist, did you pick up another piece of evidence around 5 o'clock?
Yes.
What was that?
That was an airline luggage ticket. And that was located on or an airline ticket receipt. And that was located in the garbage can south of the foyer.
And that
in the
was picked
bathroom.
up at what time?
That was picked up at around 5 o'clock.
And what item number was that assigned?
That was assigned number 15.
And what was the last piece of evidence that you came into possession of while you were at the Rockingham location in the afternoon?
Did I collect it directly or?
That you came into possession of?
That was a airline luggage ticket on the bench outside the front door.
David, did someone give you something later after the,
Sustained. Phrase the question.
did you get anything from anyone else?
Yes,
What time?
that was at 5:20 in the afternoon.
And is that an approximate time again?
I looked at my watch for this one, and I remember doing that, so it's fairly accurate.
So the other times that you've testified to at Rockingham in the afternoon are approximate except for this one.
Yes, because I definitely remember looking at my watch for this one.
What was given to you at approximately at 5:20 in the afternoon?
A envelope containing a vial of blood labeled O.J. Simpson.
Who gave it to you?
That was given to me by Detective Van Adder.
And do you recall whether it was a vial itself that you received or was it already in some sort of packaging?
It was in a gray envelope.
Okay. Your Honor, I'd like to mark an exhibit that we previously identified. It's People's Exhibit 163, and this is with the H. It's a white, gray, and yellow analyzed evidence envelope. They're all stapled together, and I marked them collectively as H.
So marked.
The counsel has seen them. They approach the witness.
You may.
So showing you these analyzed evidence envelopes. Have you seen that kind of envelope before?
Yes, I have.
And what are those three types of envelopes?
The white one is the envelope we use for storing frozen evidence. The gray one is used to store refrigerated evidence. And the yellow one is used to store things at room temperature.
Okay, so the item that you received was in the gray envelope.
Yes.
Do you know where Andrea Mazzola was at the time that you received that item from Detective Van Adder?
No, I don't.
What did you do after you received that item from Detective Van Adder?
I labeled I wrote down on the package that I had received it from him, and then I proceeded to the crime lab.
Did you use the same inventory procedure for the items that you collected in the afternoon at Rockingham before you left?
Yes.
Now, at the time that you received the evidence from Detective Van Adder, the blood vial, where was the evidence that you collected from Rockingham in the morning?
The evidence that I collected from Rockingham in the morning was in the crime scene truck. It was locked in the crime scene truck.
Okay, so that is your procedure when you have evidence in your truck and you're still working at a crime scene that the truck's locked.
Yes.
And where was the evidence at that time that you had collected at Bundy?
The Bundy evidence was also locked in the rear of the crime scene truck.
And at that time, when you received this file from Detective Van Adder, where was the evidence that you had just collected in the afternoon at Rockingham?
That evidence was next to the crime scene kit.
What is the crime scene kit?
The crime scene kit is the baggage or luggage that we use to carry about all our instruments and bags and chemicals to process crime scenes.
So were you maintaining physical possession of the items that had been collected at Rockingham in the afternoon in your crime scene kit as you collected them?
I believe they were placed in bags carried along with the crime scene kit.
Okay, but they were in your physical possession.
Yes.
So at the time that you received the blood vial from Detective Van Adder, all the evidence had either been collected and placed in the truck or was in your physical possession.
Sustained. Phrase the question.
Okay, were all the items that you collected either in the crime scene truck or in your physical possession at the time that you received the vial?
Yes.
Compound. Misleading. Where was the evidence after you collected? And
That's
as you
okay.
collected?
I think it's already clear, so I'll withdraw the
right.
the question, Your Honor. Now, after this evidence had been given to you by Detective Van Adder, what did you do with it and the rest of the items?
Could you repeat the question?
After you got the vial from Detective Van Adder, what did you do with the vial and all the other items that you collected in the afternoon at Rockingham?
I placed the items from Rockingham and the vial in the crime scene truck,
Where did you go?
and I went back to the crime lab.
Was Ms. Mazzola still with you at this
Yes,
time?
she was.
Okay. And approximately what time would you say you arrived back at the crime lab?
I arrived back at the crime lab at around 6:30 in the evening.
What did you do with the various pieces of evidence that you had collected from Rockingham and Bundy after you arrived back at the crime lab?
I transferred the items of evidence into the evidence processing room.
And is the evidence processing room there at Piper Tech?
Yes, it is.
What did you do with it once you got into the evidence processing room?
The biological evidence was further processed so that it could be dried, and another inventory of all the evidence was taken.
All right, would this be a good spot?
Yes, it would, Your Honor.
All right. Mr. Shapiro, Mr. Cochran, Ms. Clark, is there something we can agree upon at this moment?
Yes. UCLA.
Yes. All right. All right.
Trounce, Arkansas.
All right, ladies and gentlemen, we're going to stand in recess at this time. Please remember all my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case. Don't conduct any deliberations. Don't allow anybody to communicate with you with regard to the case. We will stand in recess until 9 o'clock tomorrow morning. All right, thank you, counsel. Thank you. Whether or not there is any prejudice suffered by the defendant as a result of the late disclosure. I'm interested in those two issues.
Your Honor, there are actually three items of concern to the defense with respect to our requests for sanctions.
My item of concern, I was listening while I was driving, and the socks get me confused. So, I don't know. It's just confusing. Hi, Jay. Hi, Josh. So, Anna Banana's here. He murders them. He's covered in blood. Okay? He goes home. He puts the glove back in the backyard. That doesn't make sense, because it would make sense if that was the only piece of blood that he had. But no, he's covered in blood. So, all right. So he gets rid of his pants and shirt, underwear, blah, blah, blah. But he leaves bloody socks in his room. And then he leaves the beanie, I think, in the Bronco. I don't know. But the bloody beanie in the Bronco? And how does that glove get back there? So there's no way he drives home, parks Bagley, walks the whole way down the neighbor's house, or even maybe even his own, bangs into the air conditioner, drops the glove, and then goes back into his house and leaves bloody socks on his bedroom floor, and then gets rid of his shirt and pants and stuff. That, I get it. He just committed a murder, double murder. So he's not thinking straight and clearly. I can get that far. He's not thinking straight. But it just doesn't, none of that makes sense. Now, none of that makes sense the more I think about it. Especially the fact that his socks were left in the middle of his bedroom floor. That doesn't make any sense. I don't know. I'm just gonna. All right, he wants sanctions. Let's see what sanctions he wants now.
At the close of court yesterday, it was off the record, but we noted the problem that arose with respect to Mr. Goldberg's examination of Dennis Fung. And we were able to locate the transcript reference on October 5th.
Sir, I'm sorry, but if there's going to be something involving Mr. Goldberg's questioning of the witness, may I have a moment to get Mr. Goldberg either down here or watching upstairs to make sure that nothing's misrepresented, since I wasn't here and I don't know what he's talking about.
Well, counsel, I can't wait to conduct these proceedings for the attorneys to shuffle back and forth.
Well, Your Honor, I don't know if there was any notice that Mr. Yeoman was going to argue anything with regard to sanctions.
Well, when we left yesterday afternoon, it was brought up that reference was made to items that the court had suppressed at the 1538.5. So clearly, there's going to be some severe sanction.
All right, Your Honor, I think I actually may be more familiar than Mr. Goldberg with the suppression motions.
But I'm interested in talking about the tape sanctions first.
All right, I can address that issue first, Your Honor, and then address the question of the suppression and the also the investigation with respect to the shoes. The videotape was first revealed on March 24th, I'm sorry. And of course, this was a tape that was made on June 13th. There were a number of informal requests.
It is April 4th right now. So March was just last month.
That were not on the record with respect to the production of this particular videotape. And at the time of the late production of the videotape recorded of Mr. Simpson bidding farewell to the Brown family, concerns were also again raised with respect to the existence of any other videotapes. And a specific request was made at that time, I believe on the record, for any other videotapes in the people's possession that had not been turned over. I think you need to put this in the context, Your Honor, of the importance that videotape evidence has assumed in this trial. We saw a very good example of that with respect to the prior incident involving the videotape of the night of the recital at the junior high school, where witnesses had testified that Mr. Simpson that evening was hostile and uncommunicative, and then we saw a videotape in which we could make our own judgment and in which he appeared to be very, very friendly and bidding an affectionate farewell to his children and to members of the Brown family. So this evidence has crucial significance in terms of allowing the jury and the court to make their own judgments without having descriptions of events filtered through the testimony of witnesses who may have biases one way or the other. And in light of the record of the prior failure to disclose a video, the failure of the prosecution to produce this particular videotape until March 24th takes on a special significance, especially the fact that it appeared at a point in time when it somehow seemed to the prosecution's advantage to use the tape. So the explanation that this was inadvertently mislaid is a somewhat suspicious one in view of the fact that suddenly it is relocated and brought into court at the point in time when they feel there is some evidentiary use that can be made to bolster their case. And of course, the defense was deprived of any opportunity to use this tape in prior issues that were being litigated before this court. And in a number of respects, we believe that that irretrievable.
Sir, you only present evidence to bolster your case. You only present evidence when it could be used to help you. That's the only reason why any piece of evidence is ever supplied in a trial. That's not a good argument. Next.
Prejudiced the defense. First of all, this tape would have been of substantial use in litigating the motion to suppress evidence back in September, and it would also have been quite
That's up, Josh. Come on.
Useful in cross-examining the detectives in charge of this investigation, because we have noted inconsistencies between the description of the discovery of the glove, for example, in the closet of Mr. Simpson's bedroom, as portrayed in the tape, where a single glove was removed, brought downstairs, put on a table, and appears in the videotape. That is not the way that incident was described in the affidavit for a search warrant, which was subscribed to under oath by Detective Van Adder back on June 28th. At that point, Detective Van Adder said, and this was the probable cause, you'll recall, to go back to Mr. Simpson's home and execute a second search warrant 2 weeks after the execution of the first warrant. The probable cause included the allegation that additionally, since the service of the first warrant, other officers present during that service have told your affiant that they saw another pair of gloves inside Simpson's residence. These officers had also seen the glove found at the murder location and have told your affiant that the gloves in the residence appeared to be of the same type as the one from the crime scene. Your affiant wishes to seize the gloves left in the Simpson residence because they will tend to further establish that the bloody gloves recovered belonged to Simpson in that he favored this type, style, and size of glove. These gloves were inadvertently left behind at the Simpson residence. Now, we believe that cross-examination, both of Detective Van Adder and the detectives involved in finding that glove, would have disclosed additional misrepresentations in the affidavit for the second warrant, in that the videotape reveals one glove, whereas the affidavit refers to a pair of gloves. The affidavit says the gloves were inadvertently left behind when we have since been told that the detectives actually conferred with the detectives in charge and made a decision not to seize the glove. It was not an inadvertent leaving behind. They actually decided before they left the premises that they would not take this glove or these gloves if there are two. So here we see significant areas for cross-examination that the defense was deprived of at the motion to suppress and in the cross-examination of the detectives because we did not have this tape. We did not have the opportunity to see what this tape portrays. Now, clearly, there is a parallel, I think, between the failure to produce this tape and the failure to produce the tape involved in the cross-examination of Rosa Lopez. Because in both cases, Your Honor has been presented with a very similar.
Hell no. Okay, wait a second. This guy must be on drugs. He has to be high because the defense withholds evidence for 8, 9, 10 months. And it's huge evidence. And it's evidence that the prosecutor has to go and they have to interview like 16 people to find out, everything they need to find out about it. So it's going to take weeks and weeks and weeks to deal with this information. This tape was days that they didn't turn it over. And all they had to do is say to the jury pretty darn easily, this glove was brought down from upstairs in this video. This is not where it was on the day of it. And it has absolutely nothing to do. You shouldn't read into it. It's just a glove. We didn't even bring it. We didn't even take it for evidence because it meant absolutely nothing. And then that's fine. And then they can show the video. So no, it's not even close to the same as the underhanded criminal activities that the defense team has been doing.
Explanation that a detective inadvertently mislaid the tapes and that counsel were not aware that the tapes were in existence. And that's precisely the explanation we're hearing now from the prosecution. Despite that explanation, in the case of the Rosa Lopez tape, Your Honor concluded that severe sanctions were warranted. And those sanctions included fines imposed against both lawyers, a requirement of immediate corrective action to catalog all of the statements of witnesses and indicate when they were turned over to counsel, and a proposal to instruct the jury that the failure to produce this tape could be considered in assessing the credibility of the witness. We believe that if the court is going to be even-handed in the administration of sanctions, that precisely the same sanctions are warranted here, that Your Honor should order corrective action be immediately taken to require that the prosecution immediately catalog all videotapes in their possession or in the possession of the police with a description of those tapes and an account of when they were turned over to the defense. Secondly, we have proposed a jury instruction that.
Why is this even going on though? Why don't they just not allow the tape in since it wasn't discoverable? They didn't give it to the defense team, so they just can't use it. They're just not allowed to use it. I don't understand.
Closely parallels the instruction that Your Honor proposed to give with respect to the testimony of Rosa Lopez, informing the jury that the laws governing criminal procedure in California require disclosure of evidence in advance, that the reason these laws exist is to promote the ascertainment of truth to save court time and avoid the necessity for interruptions and postponements, that the delay in the production of this tape from June 13th until March 24th was a violation of the law and the cause of delays in this trial during the week of March 27th, and that the jury may consider the effect, if any, of this delay in disclosure upon the credibility of the witnesses involved in the gathering of evidence on June 13th.
Okay, that is a lot of
That would
months.
closely parallel what the court ordered in the case of the Rosa Lopez tape. The second issue that is of concern to the defense with respect to sanctions involves the very late production, again on March 24th, of 238 pages of investigative material relating to the prosecution's attempt to identify locations in which shoes matching the shoe print left at the crime scene were sold. This investigation took place in August and September of last year. And apparently, the prosecution deliberately decided that they would not turn over any of this investigative material until their investigation had been completed. So all at once, on March 24th, the defense is handed 238 pages of material, much of which is in a foreign language. There's correspondence in that file in Japanese and Italian that we're going to have to get translated. We're going to have to conduct some follow-up investigation ourselves. And we believe, once again, we have an example of the prosecution simply withholding vital evidence until it's too late for the defense to do any investigation of their own. We believe that at a minimum, the court should delay the presentation of any evidence relating to the identification of footprints until the end of the trial. That
Delay
the court
it.
should require
That's
immediate
fair.
disclosure.
That's fair. I mean, if there's that much evidence and, they just got it, that's fair. Delay it until they have equal amount of time to do whatever they need to do with whatever that evidence is. I'm with him on that one.
Of any follow-up investigation. We need to know just as quickly as possible.
However, if they didn't conclude their investigation of this until now, then I get why they didn't turn it over. But if they concluded it last year, which it doesn't sound like they did, then no, they don't have to turn over partial investigations that aren't even done yet. Yeah, shoes. How long are we going to spend on those, I wonder? Probably a while.
What the net results of all of this were, whether they are going to be presenting any evidence identifying the source of any shoes, and we need to know that right now so we can begin to prepare to cross-examine so that the results
of the FBI testing on the shoe prints was turned over to you within a day of the court receiving it from the FBI.
What we're talking about here, Your Honor, is the effort to connect that particular shoe pattern with the sale of shoes at particular locations. I mean, this really relates to the effort of the prosecution to try to tie that shoe to Mr. Simpson. We are not aware of any evidence that in any way connects shoes of this nature with Mr. Simpson. And if they're going to put on any such evidence, engage in any attempt or inference to suggest that shoes of this type were purchased by Mr. Simpson, we need to know about that, and we need to be prepared to meet that evidence. As at this point, we have seen nothing, we have heard nothing, except this 238 pages of material that was turned over just 1 week ago. So we would ask at a minimum that the presentation of this evidence be delayed and we be given any follow-up investigation that came in its wake. The third item, Your Honor, relates to the direct examination of Mr. Fung at the close of our...
Your Honor, it's not fair. It's just like Shapiro back at the beginning. He was talking to the detectives about how they were, investigating the murders. And he was upset that they didn't know everything at the very beginning of the investigation. They didn't know everything. They had no answers for some of the things because they were still investigating. How are they supposed to know? This guy is like, I want them to turn over this information before they figure it out. I wanted to know this information before they even started investigating. They should have sent us discovery on the end of this investigation. This is not fair, Judge.
Proceedings yesterday. And as I mentioned, we have located in the transcript the court's ruling on October 5th, 1995, pages 2395 to 2396 of the transcript. And here I'm reading from the statement of the court. all right. Search warrant number 2, items 15 and 16, the ticket receipt and baggage tag. And I think Mr. Ullman was correct. I think the prosecution has the burden as to these 2 elements. Ms. Clark, that's correct, Your Honor. With respect to items 15 and 16, the prosecution will not be seeking to admit them. The court, all right, then we will take items 15 and 16 and note that they will not be offered. The representation is that they will not be offered. In the event that position should change, then the defense is entitled to a de novo hearing on the 1538 during trial if that becomes necessary. And yesterday, in violation of that agreement, Mr. Goldberg elicited from Mr. Fung testimony with respect to the seizure of both of these items, the airline ticket receipt and the baggage tag. We believe that this is a very egregious violation of counsel's duty to deliberately elicit testimony and evidence that the prosecution agreed would not be offered in frustration of the defendant's rights to seek suppression of that evidence. And we believe, once again, that severe sanctions are warranted, including the giving of an instruction to the jury. And we have fashioned a proposed instruction. We would propose that the court instruct the jury as follows. The laws governing criminal procedure in California require the exclusion of evidence that was unlawfully acquired by the police. These laws exist to protect the privacy of all citizens by deterring unlawful police conduct. Prior to the trial of this case, the prosecution represented that some items of evidence would not be offered in the trial, and the court withheld a ruling whether they were lawfully acquired. During the testimony of Mr. Fung, the prosecution violated their agreement, and you may consider the effect, if any, of this violation upon the credibility of Mr. Fung and give to it the weight to which you feel it is entitled. Your Honor will note that this instruction closely parallels the instruction that the court proposes to give with respect to Rosa Lopez. We also feel that a fine would be appropriate as a sanction in this case as well. Your Honor, in the moving papers with respect to sanctions, the defense has made a proposal to, in effect, call off this escalating war of sanctions, which is frequently characterized by hyperbole and over-dramatization and personal vituperation, and simply put over to the end of this trial, after all of the evidence is in, all of the issues with respect to what punitive sanctions are warranted in this case. While the court must, of course, immediately address questions about needs for delay in the presentation of evidence or arguments with respect to the total preclusion of evidence, we believe that preclusion is not a remedy that is going to be seriously considered with respect to any evidence in this case, that the court will more often be dealing with issues involving fines and retaliatory jury instructions. Of course, we're hopeful that the court will never have to deal with any of these issues again, but that hope certainly has not been warranted up until now. We believe there would be 3 very good advantages to the court in putting these issues over. First of all, it could expedite the presentation of the evidence to the jury, which is sequestered, and avoid the interruptions and distractions of arguments about sanctions that seem to be coming up with recurring frequency. But more important, it would allow the court to assess the issue of prejudice, the issue of willfulness, and most important, the issue of the extent to which jury instructions of this nature might undermine the reliability of the truth-finding process in the context of the entire trial, in the context of what the defense has done, what the prosecution has done, what pattern of willfulness emerges, and what degree of prejudice emerges in the context of the entire trial. I think it's interesting that in the few appellate cases considering sanctions pursuant to California's reciprocal discovery law, there have been some reversals of the imposition of sanctions, but the appellate court has the virtue or the advantage of looking at the effect of the sanctions in the context of the entire trial and how those sanctions affected the fact-finding process that was ultimately handed to the jury. There is no reason on earth why a trial court should not have the same advantage and should not be able to look at this whole question of sanctions in the context of what impact it had throughout the trial, before the final instructions are given to the jury. And if Your Honor feels that instructions are necessary, those instructions can then be incorporated into the final instructions to the jury. We believe that the third advantage this would give the court is even-handedness, that Your Honor would be able to assess the relative culpability of the defense and the prosecution at the same time, and balance the scale of what sanctions are appropriate with respect to each side. In that respect, then, we would request that Your Honor withdraw the order that you entered on March 1st with respect to sanctions relating to the Rosa Lopez tape, and simply put over this question of sanctions to the end of the trial, and address all questions of punitive sanctions and retaliatory instructions at that time. But if Your Honor is not so disposed and feels that each sanction issue should be addressed as it occurs, we would alternatively request the instructions that we have asked for with respect to the June 13th videotape, with respect to the elicitation of evidence that the prosecution agreed would not be offered, and should impose fines as sanctions.
Thank you. Ms. Lewis.
Your Honor, good morning.
Morning.
Your Honor, I believe this area of discovery violations and sanctions needs a reality check, and that reality check has to be based on the discovery laws, because as those discovery laws point out, the only orders requiring discovery that shall be made in criminal cases are as provided in this chapter. Now, the provision of the Penal Code 1054.1 requires the prosecuting attorney to disclose to the defense a variety of materials, but the preface to the disclosure of these materials is that they must be disclosed if it is in the possession of the prosecuting attorney, or if the prosecuting attorney knows it to be in the possession of the investigating agencies. The defense has failed to even make that threshold showing, which is required before any of these other issues, whether that's material, whether it's Brady or so forth, even becomes of issue. They have failed to make that threshold showing. It's uncontroverted that we did not know about this tape until March 24th. It's uncontroverted we did not have this tape in our possession.
This was the problem, though, is that throughout this litigation, it has been brought up that the defense says, we know there's another videotape because we have information from the news photographers that there was some police photographer videotaping. Where's the videotape?
Your
And
Honor,
the representation was made that it didn't exist. That's the factual basis.
well, the basis is we made inquiry. I was personally present when inquiry was made of the lead detectives in the case, and they were unaware of its existence. Excuse me. And therefore told us that nothing existed. And it's clear why they were unaware of its existence, because all of the evidence elicited yesterday supports that this was a tape made solely for administrative civil liability purposes. The tape is not only did Detective Harper, Detective Looper, the videographer, and Mr. Atkins' supervisor all testified that that was their understanding of the purpose of this tape, but the tape is self-authenticating in that regard. It does not show the pathway where the glove was recovered from. It does not show the blood drops on the driveway. It focuses extensively, I counted at about 4 to 5 minutes, on all the trophies and the valuables within the trophy room. It shows the furniture within the residence. It shows the cars within the grounds of the residence. It shows all of these items of value. And it even shows the only damage or apparent damage, which was these 2 blood drops on the light wood floor, also for civil liability purposes.
But doesn't that contradict the testimony regarding when those blood drops were collected?
I don't know why Your Honor feels it does. I don't see any contradiction in that, Your Honor. There's no item numbers shown next to those blood drops, so presumably they were collected prior to this videotape being shot. I don't see a contradiction.
Well, if they're still there, how are they collected?
Well, I imagine it's the stain, blood stains. I don't think it could be completely removed from that light-colored wood floor.
Well, I assume those light colored wood floors have a sealer on them.
Well, I don't think we can assume things like that, Your Honor.
Well, I stood on the floor.
Well,
Counsel.
I did as well, and I frankly don't recall whether it seemed to have a sealer or not, but I think that's a big leap to make, to say that because a tiny portion of this 25-minute video shows what turns out to be criminal evidence or evidence relating to the criminal investigation in the case, therefore this video becomes material in any constitutional sense or in any sense at all in terms of defense discovery.
Well, the problem I have, though, Ms. Lewis, is this. The request was made several times by defense counsel that they knew or had reason to believe that this tape existed. And they asked several times for it. And we got representations back several times. It doesn't exist.
Your Honor,
Now we find it exists.
it was our belief that it did not exist, and it is understandable how that happened, since it was made for this purely administrative purpose and was placed by Detective Looper, who's not been part of the discovery process, is not one of the lead detectives in the case, was placed by him in a file cabinet because and he only thought of it when it became known to him that he was going to be testifying in the case. So that's when he thought of it. That's when it occurred to him to look for aids that might be useful in refreshing his recollection during his testimony. He thought of it. He brought it to the attention of the lead detectives. They immediately told us. We immediately had it copied as soon as our lab was available. It was a Friday, I believe, that we discovered it, and we turned it over the following Monday. It may be unfortunate that this tape was not depicted sooner, but there's an additional point to be made. When you talk about defense prejudice, even assuming it was discoverable, and it was not, Your Honor, and I don't care if they made specific requests. If we had not planned, now that we know about this tape, we would like to use parts of it. We would have liked to have had it months ago and used parts of it in various other hearings. But even at this point in time, if we did not intend to use that tape at trial, it would not be discoverable. I don't care if they personally requested it or made a specific request for it. This is not Brady material. And in fact, under Brady, there need not be a specific request made. So that when we're talking about sanctions, we're talking about imposing sanctions on the prosecution, that is a serious allegation and a serious matter. And it was serious for the defense, it's serious for us, but we're in a different context than the defense was in the Rosa Lopez matter. I'm going to talk about that in a moment. We're in a situation where we had no obligation to provide this discovery. If we had known about it, we would have. Of course, it would have been useful in examining the witnesses. It would have been useful during direct examination, not just cross-examination by the defense. We would have liked to have had this video, but we did not. And the fact that we do have discovered it now is simply to everyone's benefit. It doesn't mean that there was any prejudice inured to the defense. They failed to show any prejudice whatsoever in not having it. And along those lines, the photographs that the defense has had in their possession for months are actually much better evidence, as Detective Looper, I believe it was, alluded to when he testified yesterday, because the photographs show this evidence when it was recovered, after it was recovered. It shows all these blood drops. It shows everything in better detail because those photographs were taken indeed for criminal investigation purposes under perhaps under subdivision C of Penal Code Section 1054.1. Those are real evidence intended and shot for the purpose of criminal investigation purposes. So those photographs were discoverable. They were turned over. They're certainly the best recordation, much better than this video, of all of the crime scene evidence and the locations where items were recovered. The photographs show the pathway, the glove, and so forth. They show the criminal aspects of this case. They don't show all the valuable Heisman Trophy and all the other valuable trophies that the defendant had because those were not part of the criminal investigation in this case, and there was no reason for those still photographs to depict them. The only thing that is shown on the videotape, which is not shown in these crime scene photos, that might have had some significance was the linen closet, which was fingerprint dusted. But as Detective Looper testified yesterday, no fingerprints were recovered. There was nothing of evidentiary significance about the linen closet. And I don't believe the court has heard any testimony. I don't recall in the months I've been involved in this case, any testimony having to do with the linen closet because there's been nothing relevant about it. So there is nothing on this videotape that is not better depicted, much better depicted within the photographs the defense has had for months. Now, Your Honor, the Rosa Lopez situation is entirely different. The defense under Penal Code Section 1054.3, Subdivision A, requires, the law I should say, requires the defense to turn over the statements of witnesses they intend to call at trial, recorded statements, recorded in any manner. The Rosa Lopez was on the defense September 1st, 1994 witness list. So their intention to call her at trial was clear and present for months before that tape was discovered. Now we have the defense would like to draw us into this, and it's the same situation as they're in, but we're not. The discovery statute, when it talks about if it's in the possession of the prosecuting attorney, or if the prosecuting attorney knows it to be in the possession of the investigating agencies under 1054.1, which is the statute that covers our obligation, makes that critical distinction between us and the police.
Do you think the 1054.1, that a reasonable interpretation creates an obligation for the prosecution to make reasonable inquiry and diligent search for these items?
We did, Your Honor. We did. We
No, I'm
wanted,
not asking you whether or not you did.
Well,
You agree that a reasonable interpretation of that code section
yes.
requires inquiry to be made.
Yes, I think that is a reasonable interpretation of that code section. But unlike that section, the defense, the section governing the defense obligations, discovery obligations, makes no distinction between the defense attorneys and the defense investigators. And that's clear why. The police department is a separate agency, a separate entity. It's not even a county department, it's a city department. We're in total different forms of government or totally different bureaucracies. We don't pay the police. We don't order the police around. The police aren't beholden to the DA's office. We don't pay their salaries. They have similar goals that we do in terms of some criminal prosecutions. So of course we work in conjunction, but it's a different situation when you look at the defense side of the table. Their defense investigators are employed directly by them. They do take orders directly from them. And that distinction is recognized in the discovery statutes by the failure of the statute governing defense discovery to make any distinction between the defense attorneys and their investigators. So when it came to the Rosa Lopez tape, the defense attorneys were charged with the knowledge of that tape that Mr. Pavlik had in his possession. Not so with us, and that's not so because of the express terms of the statute. So we're talking about apples and oranges. In addition, of course, the defense, when it comes to the civil liability aspect of this particular videotape, the DA's office wouldn't be sued if the police had seen to have done something to cause damage to those premises. The Los Angeles Police Department would be sued, and they have been sued. And they do have the choice now. The detectives have the choice of recording either by videotape or by still photos locations where search warrants are executed to make sure that they've got a record of that in case of a later suit. I'm sure the court's aware the department sued all the time. So they have different administrative liabilities and problems than does the DA's office. I guess we get our own lawsuits in some respects, but certainly nothing to do with the execution of search warrants. And Your Honor, the defense keeps talking about this recital tape. We're not talking about the recital tape anymore. The court made inquiry about that of the June 12th recital that the defendant attended. The court made inquiry. We didn't know we had it. Apparently, I don't remember exactly how that came about because I wasn't personally involved with that. But when we found it, we turned it over. It certainly was not material evidence. And, and the court has to consider that this, as I said, even
Ms. Lewis, how can you say that it's not material evidence where the prosecution's theory is that there was this tension and anger expressed by the defendant on the date in question at the dance recital, and that he was glowering at people and was in another emotional state of mind, and yet we see him greeting the Brown or saying goodbye to the Brown family and smiling and greeting his children. I mean, that's directly contradictory to the testimony of the prosecution witness. So how can you say that that wasn't material?
No, to the contrary, Your Honor, it directly supports the entire prosecution theory. When Mr. Simpson was inside that auditorium, when he wasn't in the public domain where people would be looking at him, he's thinking about other things. That's when the witnesses testified as to those expressions. When he got outside, was aware, greeting people and was aware, that became his public persona. And as Mr. Darden told the jury during opening statement, this man has two personas. He has the public face and he has the private face.
All right, let's move on to the FBI shoe print matters.
The defense, Your Honor, has still failed to show how these materials fall under the discovery laws. As I indicated to the court the other day when this whole issue first came up, these materials are basically correspondence. They're materials sent out by the FBI to manufacturers in an effort to investigate this whole shoe area.
Do you plan on calling Bill Boats yet?
Yes.
Aren't these his work material and his reports and his efforts to investigate?
Well, these are investigative efforts. I would call them investigative efforts. And they have now been turned over. But, the investigation is ongoing. We may not have seen the end of the shoe evidence. It is ongoing today as we speak. There are people investigating this area. And, I don't want to fill the court in on the details, but.
Well, the problem I have, though, is that these reports go back to August of 1994. These
are not
letters and this
reports.
correspondence.
Your Honor, these are not reports. Let's make that clear. These are not the reports of experts, and they're not even the experts' notes. It's correspondence as part of the investigation. I'd invite the court to take a look at what we're talking about, because this material clearly does not fall under the discovery laws. We've chosen to make it available, give it to the defense. But even the cover letter from the FBI indicates that they've reviewed all the discovery requests directed to the FBI, and unless otherwise noted, have complied with each of them. Even though many are clearly outside the normal scope of discovery. That's the letter from Mr. Shapiro, General Counsel for the FBI. So he's saying that we're going to give you everything, even though it is outside the normal course of discovery. And, as Mr. Goldberg actually pointed out the other day, because we've been so generous in this case and have, I'm not sure he pointed this out, I won't lay it on him, but I'll make the point, that because we have been so generous in this case and going through hoops and providing the defense with an incredible amount of discovery, way beyond what we were ever required under the law to do, they're turning around trying to slap us in the face with it. We've given them too much. This stuff is not even discoverable. If we'd not given it to them, they would have not known about it. Here they have it weeks in advance of any evidence coming on with regard to the shoes. They have it when they don't even have to get it, and we gave it to them as an extra courtesy. But let's go back, Your Honor, as we've made the point in previous motions. We did provide, I think it's over 23,000 or maybe more by now, pages of discovery, hundreds of videotapes, audio tapes, etc.
Let me ask you this, Ms. Lewis. I only was provided with a few what were deemed by the defense to be representative pieces of that 238 pages of material regarding the shoes from the FBI, which seemed to indicate a search to identify that particular sole pattern, is my recollection of what I read. Have you identified, to your knowledge, that shoe pattern?
We've identified the shoe pattern, yes, as being that of a Bruno Magli shoe, Bruno Magli. Indeed, Your Honor, the defense was provided with the reports and the final discovery and what is discoverable. These, when it comes to experts, not the whole world is discoverable. As the court knows, the court did a lengthy in camera. I'm assuming that we prosecutors did not get every bit of information. I'm sure the court made a careful evaluation in determining what was discoverable and what was not. And in this case, it was obvious to us clearly that this is material which is not readily discoverable. It's not provided, and we did provide the bottom line reports with regard to those shoe prints.
What I was getting at is Ms. Lewis, is what is the materiality of the items that were turned over? What is there?
There is no materiality of the items that were turned over. I'd be happy to lodge. This happens to be our only copy, but we can make a copy, or I'd lodge our
All right,
originals.
would you have your staff make a photocopy of that and lodge it with the court so I can read it?
I'd be happy to do that, and we'll do that, Your Honor.
All right, would you address the testimony of Mr. Fung regarding items that were withdrawn by the prosecution?
I will, Your Honor. I had one final point I wanted to make. I wanted the court to be aware that its favorite language in the Augers case was not overruled by the Bagley case, as the defense, Mr. Thompson, Mr. Thompson, the defense attorney, made the representation the other day. The Bagley case reaffirms Augers and talks about when something is considered constitutionally material. But even in the Bagley case, it was undisputed that the material was Brady material that was at issue in that case. There were contracts with prosecution witnesses as far as what payment they would receive, depending on how much information they gave. So that was clearly and obviously Brady material. But there has to be a showing of constitutional materiality, Your Honor, for something to be discoverable under Brady, and there's nothing even close to that in this videotape. And I'll reiterate the point that the stills photographs show better. Everything that the video show better, because it shows not only during the early
Right,
time, but
Counsel, you made that point already.
I
What I'm
realize that,
interested in.
All
what I'm
right, with
interested
the court's permission, since I wasn't present yesterday, and I know what the issue is, but Mr. Goldberg would like to address the court with regard to Mr. Fung's testimony.
Good morning, Mr. Goldberg.
Just to clarify the record, I think to my recollection, it was Mr. Scheck who made the comment about Augers being recalled. I nodded at the inappropriate time while Ms. Lewis was looking to me for affirmation. I think it was he and not Mr. Thompson, so I did not want to have the court misled in that regard. Not that it's that particularly important. On the issue of the testimony by Mr. Fung, this is a situation, Your Honor, where the prosecution immediately upon realizing, specifically me upon realizing that question should not have been asked because it was eliciting information that had been suppressed, instantly agreed with the defense that it should not have been asked, it should not have been elicited. And Ms. Clark agreed. So this did not require any argument. It did not require looking at the transcript. And I just don't understand why Dean Ullman would feel that it is necessary to go back and argue from a legal perspective something that we had immediately conceded, unless he's interested in simply the public excoriation of the prosecution, or in this case, of me. I just don't understand the necessity of that. I would agree with the dean that there has been an escalation in terms of requests for sanctions, perhaps because the defense, in our view, was legitimately sanctioned for some very serious discovery violations in instances where there was at least circumstantial evidence, strong circumstantial evidence, I believe in the court's opinion, that there was either intentional or negligent misrepresentations that were made before this court regarding issues that went right to the credibility of material witnesses.
Let's put those other issues aside as being apricots and oranges at this point.
Well,
My interest here is, given the agreement of the prosecution to withdraw those items, how did this happen?
Well, Your Honor, the way that it happened is very simple. I was not here when that happened. As the court knows, I was a relatively speaking recent addition to the prosecution in this case. There are a large number of issues that were litigated, and I did not know about that. It was not communicated to me. It was an error. It was a mistake. We made a mistake.
Doesn't the prosecution have some obligation within the team members to communicate with each other and organize the presentation of this case?
Of course, Your Honor, and we have done that. But does the court honestly believe, I'd ask this question rhetorically, that I am going to ask Ms. Clark, were the airline tickets suppressed? I mean, of course I have been communicating with her about my presentation of the case and all the tactical issues and how we're going to present it. I think that Your Honor recognizes that. But no, I did not ask her whether the airline tickets were suppressed. And if I should have, and I failed to, then I made a mistake. But I did not ask that question. Sorry, they were not suppressed. They were litigated, as Ms. Lewis just pointed out. What I would say on this issue is my sole reason for asking that question was not because I thought there was anything relevant or material per se about them, but I simply wanted to get the sequence of events, particularly as it related to Detective Van Adder giving the blood vial to Mr. Fung. I wanted to be very careful in terms of our presentation of that part of the evidence and what sequence of events occurred and what pieces of evidence he collected just before he left and received that vial. The airline tickets themselves, it would seem to me, based upon what the jury has heard of this, if anything, would be something that would be somewhat favorable to the defense in the sense that it would seem to indicate that the trip was a planned one as opposed to being unplanned. So it certainly doesn't have any evidentiary value in terms of the content of the evidence as opposed to the timing sequence as far as the people are concerned. And from a legal perspective, when the issue of an instruction to the jury is raised, what I would point out to this court is that it is a well-recognized principle of law that unless an objection is lodged, the objection is waived. And there was no objection by counsel. I don't know. They haven't even represented to the court in good faith that they didn't intend to introduce the evidence themselves of the airline tickets. So they didn't object to it. They didn't do anything until they discussed it at sidebar with Your Honor and with Ms. Clark and myself.
At the end of the day.
At the end of the day. But they didn't object at the time when an objection could have been sustained to the question and at a time when any evidence could have been precluded. So legally speaking, I think that we would be entitled to take the position from a legal standpoint that there is nothing more for the court to do. That's not the position I'm taking. If the court wants to admonish, if the defense wants this, that question and that answer is struck, we would concede that that is an appropriate way of handling it. Legally, it may not be necessary, but we would concede that that is an appropriate thing for the court to do. But to give an instruction of the kind that Ullman is proposing doesn't make any sense. And the only reason that I compared this alleged violation to certain of the other violations that Mr. Ullman discussed is because he drew a comparison and he was analogizing to the instruction that the court was proposing to give for the Rosa Lopez incident. And they are not analogous, because what happened in the Rosa Lopez incident is that the prosecution was deprived of, until the last minute, materials that were very significant in terms of the cross-examination and the credibility of that witness. There's been no analogous violation by the prosecution with respect to Mr. Fung. What has happened with Mr. Fung is I asked him a question that he had absolutely no way of knowing was improper, and he answered it as he's required to do as a witness. It in no way reflects upon his credibility. It in no way reflects or diminishes the capacity of the defense attorneys to cross-examine Mr. Fung effectively, or deprives them of materials to make the cross-examination effective, or deprives them of the opportunity to have a sufficient period of time to examine those materials. So you're not dealing with any of the problems that you are in the case of Rosa Lopez, where discovery was held back on some very important statements that she made that we used for the purposes of impeachment. I don't know whether the court wants me to address the issue of fines. I will if the court wants to hear about that.
Well, it's something that might happen, so this is your chance to say something.
Okay. As to the issue of fines, first of all, in the criminal context, there is no statutory authority for the imposition of crimes to the same extent that there is in the civil context. It's been a while since I practiced any civil law, but the Code of Civil Procedure does provide for the imposition of fines for a wide variety of things in addition to discovery violations. I believe that a court in a civil hearing.
I know it's 9 o'clock and I know I should stop right now, and I can't. And this is this goes on, I don't know. This looks like it goes, oh wait, Marcia talks today. I don't know if I can go another hour, but I can't stop right now. I need to know. I have to know what happens with these sanctions. I just have to.
Hearing can fine counsel for making frivolous motions.
I just want you to know I understand your time, and I understand that you have things to do, and I do understand that me going long affects your lives. I understand that. But you can just go away and come back and watch it later if you want. You can. Or you can watch it on double speed later, and then it'll just take a little bit more, but I cannot stop right now. I have to keep going.
Perhaps some viewers of this case wish that the court had the authority to do that here. But there is case law to indicate that the Code of Civil Procedure sections dealing with do not apply in the context of a criminal case. We do have now in the post-Proposition 115 context is a specific provision in 1054 for fines for discovery violations, but that's it. So legally, there is no basis for fines outside of that area, unless the court were to hold the prosecution or me in contempt and then to fine me that way. But other than that, there's no authority for the imposition of a fine.
Don't you think I have authority under CCP 177.5, the court having ordered that before any new mention was made by the prosecution, that notice was to be given to the defense, and that they were then entitled to a de novo 1538.5?
Judge was chill until he said, "You don't have the authority to do that to me, Judge." Judge was chill this whole time. Then this guy, "You don't have jurisdiction, Judge." Okay, dumbass. Now the judge is gonna get you. You're not my mom.
No, that's what I'm saying is I don't believe that the Code of Civil Procedures sections apply in a criminal context with respect
All
to
right, well, the
fines.
case law is pretty clear that I have authority under 177.5 to impose fines.
I'd have to look that up then, Your Honor, because I thought I read a case several years back that said that the court did not. But I may be mistaken about that, so I don't want to represent something based upon my recollections of a case that I read a
Keep
very long time
arguing.
ago.
That's a good idea.
All right, well, just so you understand, it's my position that I have the ability to impose sanctions up to $1,500.
Yes, sir.
Okay.
I understand, sir.
And I feel comfortable with that.
Okay, if the court were inclined to
sorry,
do so,
sir.
I'd like an opportunity to go back and find that case because I do have it
Dumbass,
in my
shut
computer.
up.
Unfortunately, it's at home. I did not know that counsel was going to be asking for fines because when we had our little discussion, it seemed like Mr. Cochran and I think maybe Mr. Shapiro was there, felt that this was not a major deal and that a lot more is being made of it than was yesterday evening. The other thing I'd say on the issue of fines, it has to do more with a practice in our legal community than with the actual law, and that is that I'd like to point out that the prosecution did not request fines of the defense attorneys in this case as a result of the discovery violations. And there are a number of reasons that we didn't do so, and I'm not in any way criticizing the imposition of fines by the.
Can I just say, if they fought this hard for their case, for their case in chief, for the murder of, 2 victims, if they fought this hard, they would probably be a lot further than they're fighting for these fines.
Court, but it is our feeling that it is not appropriate in that kind of a situation for an advocate to ask for fines against another advocate, even for something that amounts to an intentional or reckless misrepresentation. And that was our reason for not doing so. I'm not in any way commenting upon the imposition of fines by Your Honor. We're just saying what our position was and why we didn't ask for that. I believe, based upon my practice, that there is a unwritten rule that fines are generally not imposed and generally not requested by criminal practitioners in our local legal community.
But it's a sanction that the court has available to it to maintain order in the court and to maintain respect for the orders that the court makes. So it's a sanction that the court uses, not necessarily at the request of the parties.
Well, I was just explaining to Your Honor why we did not request it. And I'm also explaining why we are somewhat surprised by the fact that Dean Ullman has requested this and somewhat surprised by the fact that the defense has requested it in general.
Well, they didn't like the fines that they got. That's the basis for that. I
But
understand.
I'm just saying that we did not ask for them. I was pointing that out. Yes, Your Honor is right. You do have the capacity to maintain order. But what I would suggest on that issue is, how is it going to maintain order of this court by imposing a fine? How is it going to deter any future violation of something that we are entirely unaware of and that a reasonable person would not have made inquiry into? Yes, I did discuss my aspects of the case with Ms. Clark, but as I said, Your Honor, I did not ask specifically whether the airline tickets had been suppressed. And if the court is concerned about deterring future incidences of this kind, I don't see how the court can deter that kind of unintentional mistake. It is not the first mistake that has been made in this case. It won't be the last. There are going to be other issues that come up by both sides. I think we know that, and that is a fair statement based upon what has happened here before. So I'd ask the court to consider all those issues, but more importantly on the issue of an instruction, because that would adversely impact the interests of our client, the people, and adversely impact the credibility of this witness if the court were to give any instruction of the kind that Mr. Ullman has proposed. That is simply entirely unfound from a legal perspective, from a common sense perspective. It in no way relates to this witness's credibility. That information that was agreed not to be elicited was put before the court. And we would ask the court simply to tell the jury that the question and the answer to the question are stricken.
All right, Dean Ullman, 10 minutes.
Listening to the response of counsel was somewhat of a deja vu experience. We were hearing lots of echoes of the argument that preceded the court's imposition of sanctions against the defense. I wasn't there defense. I recall that Mr. Cochran's declaration to the court indicated that he came into the case later, that he did not direct the activity of Mr. Pavlik as his explanation of why he wasn't aware that the tape existed with respect to Rosa Lopez, that we didn't know it existed defense.
Well, let's not relitigate that issue.
All right. Well, there's one thing that wasn't echoed, Your Honor, and that was any expression of contrition. No apology. In fact, defiance. In fact, the suggestion being made that we've been overly generous in what we've turned over to the defense. Your Honor, there's an attitude problem here. And frankly, the response of the prosecution, I think, should create greater alarm for the court. It certainly creates greater alarm for us than existed prior to hearing what they had to say. I mean, the suggestion that whatever the police have in their file cabinets, we have no responsibility to inquire into except to ask them if they have it. That this is not Brady material, that evidence of the significance of the videotape of Mr. Simpson's demeanor on the day that the murder took place, 3 hours before the murder took place, that's not Brady material. That this tape shown the very day after of the condition of the premises and showing the blood spots, and the suggestion that this was just an administrative videotape just doesn't wash. If there was any concern that the people or the police or the prosecution might have had that there would be some liability for the premises, the condition in which they left Mr. Simpson's premises, you would have think that we would have had a videotape showing the plumbing job in which they actually removed the drain pipes from some of the plumbing from the sink in Mr. Simpson's bedroom. That's not even on the tape. What is on the tape is a portrayal of gloves, a portrayal of blood spots, items that are of great evidentiary significance in this case. And I think what we see is an attitude that just doesn't recognize that there is an obligation to make this kind of evidence available to the defense. And we would seriously suggest that perhaps Your Honor needs to order that the prosecution have a look at what's in the file cabinets. I mean, the suggestion that police can just put things in the file cabinets and we don't need to worry about what's there. Frankly, we're worried. We're more worried now than we were before. If these two items that have shown up tardily are an example of what else may exist in police files, we think Your Honor should order the prosecution to make a complete examination of all of the evidentiary items and reports in the possession of the police department, and that Your Honor, if there is any question at all, should yourself examine this material and apply a true standard of what Brady requires. Apparently, the prosecution just doesn't have any conception of what their Brady obligations are. Now, with respect to the specific items here, the videotape, first of all, Your Honor is correct that the specific inquiry was made as to the existence of that tape. So what we have here is conduct bordering on willfulness, certainly conduct showing recklessness, and certainly no greater showing of willfulness than existed with respect to the Rosa Lopez tape.
Are you seeking the suppression of the tape?
No, we are not. We are not asking for preclusion with respect to this tape. We believe there is evidence in this tape that is favorable to the defense that we may want to use. The prejudice we're asserting, though, is that we got it so late that we couldn't use it in our motion to suppress. We couldn't use it in cross-examining the detectives in charge of the investigation, and counsel didn't even address the question of the inconsistencies between what this tape suggests and what the search warrant affidavit suggested. So we believe we have made an ample showing of prejudice with respect to the failure to produce this tape at an earlier point. With respect to the investigation of the shoes, the explanation that an investigation is ongoing does nothing. In fact, it suggests, once again, that the prosecution interprets their obligation as simply doing their investigation, and then when they're done, turning over the results of their investigation.
No, 1054.7 provides the means to shield confidential matters if it's necessary to do so to complete an investigation. That argument doesn't fly.
Okay,
So don't waste
and
your
they
time
should
with
have come to you and
Don't waste your
sought
time with
that.
it.
All right. With respect to the relevance of that material, for us to do follow-up investigation, there's a lengthy chain of distribution that the prosecution is attempting to track down, showing what manufacturers were allowed to use this pattern, which of those manufacturers exported to the United States, where in the United States shoes that have this pattern were on sale. There's a lengthy chain of distribution that we are going to have to retrace if in fact they are going to offer evidence to suggest somehow that these shoes were available for sale in the United States in a place where the defendant might have acquired them.
Do these 238 pages deal with that?
They do indeed. They are inquiries to specific manufacturers to specific distributors in an attempt to track down where these shoes were distributed and sold. And finally, with respect to the issue on the suppression, I think it goes without saying that any counsel who comes into the
We've been at it for well over 4 hours, guys, so make sure you eat something. I just made some fruit salad. Apples, grapes, mandarin oranges, strawberries, and mango. But before you say anything, look. Oh God, please. This is the color of our mango. When you live in Pennsylvania, fruit, I mean, this is the size of my grape, which is very, 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 very tiny. We don't get fruit like you guys get down there. I mean, we can get good fruit. We can. But it's not always promised and it's not always a given. This mango, ooh, I'm trying to pull it apart because that's what we get right now. But the apples are delicious because we live in Pennsylvania. We do apples, right?
case is going to have to familiarize himself or herself with the prior rulings of the case. I mean, if the defense or the prosecution can just bring in a new lawyer and ignore prior agreements and rulings of the court, and then when called to account say, well, I wasn't here when that happened, there's no way that, that this court can conduct a reasonable trial. The objection was made immediately after the close of court yesterday, and as I recall, these were the last questions addressed to Mr. Fung at the end of his testimony yesterday. So certainly, I don't think we can suggest that the defense waived this issue by not making a prompt objection. We believe that simply striking the question and the answer does not communicate the degree of egregious misconduct by counsel involved in asking and answering these questions. Now, Mr. Goldberg says, well, an instruction doesn't make any sense. To tell the jury that they should consider this with respect to the credibility of Mr. Fung makes no sense because it has nothing to do with the credibility of Mr. Fung. That overlooks the nature of the jury instruction as a punitive measure. The failure to promptly disclose the tape involving Rosa Lopez didn't have anything to do with her credibility either.
Yes, it does.
It does not, Your Honor.
Yes, it does.
I respectfully suggest that the tape was produced, they did have it, and they were allowed to use it for cross-examination.
Which is
The delay-
precisely why it goes to her credibility.
The tape goes to her credibility,
Absolutely.
right. But does the delay of the defense in disclosing the tape go to her credibility?
And that's for the jury to decide.
That is for the jury to decide as a punitive measure, to punish the defense for not producing the tape. And by the same token, we would say it's for the jury to decide what credibility they should give Mr. Fung's testimony when the prosecution deliberately elicits evidence and testimony that the pretrial agreements provided were not to be elicited.
All right, counsel, wind it up, please.
All right. With respect to the fines, again, we're simply asking that the court be even-handed and address the question of sanctions from the same perspective that you addressed them with respect to the defense counsel. In fact, we have suggested much more modest fines because we do not want to deprive the prosecutors of the means to come to court suitably attired. But I can certainly
They
loan
can
them
buy their clothes at
some
Penny's
sackcloth.
like you do.
I think they'd look good in it at this point, certainly better than I would look in a dress. To conclude, Your Honor, I think, frankly, the best way to handle this whole situation is simply withdraw the order of March 1st and put over to the end of the trial all issues of punitive sanctions, so Your Honor has the benefit of a full record of the conduct of counsel throughout the trial at the time you address these issues.
Thank you, counsel.
Your Honor, just for the record, there was no plumbing torn up or taken or done anything else with on the 13th.
Yo, Miss Lewis did a good job today, didn't she? She really did.
All right, court will make the following order immediately. The district attorney's office is ordered to prepare and submit to the court by the close of business April 7 an inventory of all video tapes that are in existence either in the possession of the district attorney's office, the Los Angeles Police Department, or any other agency.
First off, he already ordered that once before. Second off, How can they turn over tapes in the possession of the police department or anyone else if they're not in possession of them? I would love to turn over to Donald $1 million that Nan might have because, you know, I'm nice. But I don't have possession of Nan's money. How can I turn it over to Donald? Sorry, Donald, but you get nothing. And just like the defense team is going to get nothing.
That is involved in the investigation of this case. The district attorney's office is ordered to prepare and submit to the court by the close of business Friday an inventory of all reports, letters, and other items regarding the shoe evidence. Court will take under submission the request for sanctions, monetary sanctions, as to all three of these items. And Mr. Allman, will you submit to the court the draft language of your instruction regarding the ticket and baggage receipt?
Your Honor, videotapes, could you, there be a little bit more specific, because there is news footage, I think, that our
Videotapes.
media relations department has taped this case for days and days and days.
Inventory of all videotapes. All. Friday, noon.
Including all the news shows we've taped for the last several months. I don't mean to be impertinent.
Is there a
All
videotape?
videotapes. Each and every one. This is the second time the prosecution has popped up late with a videotape.
This one was not in possession. I've already made that point.
But we knew it existed and inquiry was made several times.
Well, we didn't, as I told you, we did not know it existed.
Well,
Detective Looper did, but we didn't.
Detective Luper's part of the prosecution team, I take it.
Not under the penal code section covering our discovery obligations. Your
I
Honor.
agree. I think the prosecution is very fortunate that that statute was written by prosecutors.
That's by the voters of the state, Your Honor. That was an issue that the
Oh, I
voters
agree, and
approved
that's the disability that the defense has, because the defense obligations are spelled out much more clearly than the prosecutor's obligations are. It's an interesting statute. All right, we'll take a 10-minute court report.
What about the tape that Marcia and Dearden is gonna release later?
Go to recess. Then we need to take up the presumptive test issue. I'd like to see counsel in chambers for the 10-minute recess. I want to know what your position is on the presumptive blood test.
All right. Fine. We made it to the end. It sounds like he is going to read those instructions to the jury. And it sounds like, I don't know. I don't think he's going to put in that you have to gauge Fung's testimony on the facts that these tapes were late. He did it with Rosa, but I don't think he's going to with Fung. I just don't. I like when the lawyers argue with the judge and the judge is like, no, that's stupid. All right. Thank you so much for coming out today, guys. I shall see you again very soon. I hope you guys have a great day. Bye, guys.